Good evening. I'm Sandy Thomson, the host of the show, which is called Life Ahead. Welcome here to PBS Fort Wayne, and welcome to our show Life Ahead. If you've never watched it before, let me tell you just a little bit about it. It's a half-hour talk show, and we have live callers, and we invite you to call in with your questions. Each Wednesday night at 7:30, we have a new topic, a new guest, so you just never know what you're going to stumble across. But we try to give you educational and information that will help you in your choices for your life ahead, thus the title of the show. Okay, get ready to call us here. We have an attorney with us tonight, so legal is the theme here this evening. And if you have watched us regularly, you know my guest. He's been on a lot, especially in this last 6 months or so. This is Bryan Nugen. Bryan, welcome again.
Thank you, Sandy.
Bryan, by the way, specializes as an elder law attorney, but I mean, law in general we can talk about.
We can.
Kinda?
Of course. We'll give it a try. If they call in and ask, I'll do my best.
Okay. All right. Well, we're going to talk about some of the things that you look for in elder law situations that you might have. Bryan can give you some expert advice if you want to give us a call. Bryan, until people do ring the phone here, let me ask you some questions.
Sure.
What are some of the most challenging legal situations that you deal with as an attorney helping people with elder law issues?
I think in regard to elder law, if there is within the family, if there's a schism or the folks aren't all on the same page, it can be difficult to make sure that their estate plan is in place as they want it to be, and to be fair to typically all their children. So for example, if a client has multiple children and maybe they've helped one child more than the others through the years for whatever reason, the clients can debate about how is it that we continue treating our children fairly despite the fact that we've maybe helped one child along the way much more. That can be challenging. I would say also when we have situations where a guardianship is necessary, maybe someone is incompetent or is making poor decisions, and so we need to go to court and establish a guardianship for them. That sometimes can be heartbreaking, and that we have to bring in a doctor, and the doctor would indicate that no, the person can no longer make decisions for themselves. And again, back to what I was saying earlier, if there's a division in the family about who it is that would be most responsible and best in a situation to provide care for the individual that the guardianship is being established for, that can create a lot of tension and drama in the family. So those are some of the challenging situations. They can be rewarding as well when you're solving some problems for the family members, for the clients. But I would say challenging situations like that when you're looking for equity or trying to provide care for someone that maybe doesn't want it or doesn't appreciate the fact that they really are in a situation where they need help.
Right. Yeah. And that I know can be the situation a lot of people, and we've talked about this a lot here on Life Ahead. The trend now is that people want to stay in their homes as long as they can.
True.
So whatever can be done for them in terms of medical care, household things, financial, whatever, to help keep them in the home longer.
Sure.
And often it takes a legal situation to make those things happen, is often to the benefit of the person. Okay, let's talk about healthcare and housing. If you would address those, healthcare and housing,
Sure.
And what kind of situations or legal situations do you encounter?
Well, you mentioned earlier about people wanting to stay in their home, so we call that aging in place. How is it that we can allow someone to successfully age in place? I always tell clients, and I'm sure that other elder law attorneys do as well, if you're looking to age in place in your home, we want you to have some things there. For example, we want to make sure that your bedroom is on the main floor. It sounds very basic, but your bedroom is on the main floor. You have a bathroom on the main floor that you can easily get into and out of. If we have roll-in showers, or at the very least walk-in showers, the situation where you're having to step over a bathtub to get into the shower is not a good situation if you're wanting to age in place. So spend some money on remodeling that bathroom and making sure it's appropriate for you. I've had situations where clients were in older homes and maybe their washer and dryer are in the basement. Well, that doesn't work as we age. We want those appliances to be on the first floor so that you have access to them. Also, making sure that you have a good network around you to provide care for you as you age in place. Have you put those documents in place, your healthcare representative designation, your HIPAA waiver, et cetera, that if a decision needs to be made about your healthcare and you're unable to do that yourself, do you have those documents in place so somebody can successfully make decisions on your behalf? Durable powers of attorney. Seems very basic, but everybody should have a power of attorney. This is indicating who it is that can sign checks for you, make financial decisions on your behalf if you're unable to do so, or you couldn't get to the bank yourself, couldn't speak with someone. So surround yourself with that village that's going to provide care for you as you age successfully in place. Also, I think that it's important to make sure that as you age, your primary care physician maybe is used to working with folks that have geriatric issues, so that your care, it may change as you mature, and you'll want to be sure that you have someone that's able to work with you as you age and be able to identify issues and assist with you.
Your physician, is that what you're talking about?
Yep.
Your family physician?
Primary care physician, somebody that would be used to working with geriatrics. If you don't be shy, actually, to get a little bit of help in the home. Sometimes having attendant care in your home, and when I say attendant care, I mean someone that's assisting with activities of daily living, like bathing, dressing, medication reminders, assisting you to the restroom if need be, maybe doing some laundry and light cleaning. You'll want to have that in place. And I found that people, when they're reaching out for that help, they feel like it's a sign of weakness. And if I need that help, someone's going to feel like I can't remain in my home anymore. I need to move out of my home. Actually, to the contrary, I think if you're establishing a relationship with an agency maybe that's providing care for you in your home, it will allow you to stay there longer. And it isn't that you're getting somebody in the home Sunday through Monday, or I should say Monday through Sunday, 7 days a week. It could be that you start out having 2 hours on a Monday, 2 hours on a Thursday, just to make sure the home is clean, linens are changed on the bed, your laundry is there, maybe to make some meals so you have some decent food in the home, and able to keep you there as long as you can. So making sure the environment that you're in is appropriate for you as you age, getting some of those basic legal documents in place so that if a situation arises where others need to make decisions for you or help you make those decisions, you've got that in place. And then looking for care in the home so to make sure that you can age there as well successfully.
Good points. Good points. And I want to mention, you talked about getting your home ready for those elder years.
Yep.
I was recently talking to a builder and said that it's really a trend now that people are maybe trading or building a new home as they move into senior years and for their forever home or retirement home. And even if they're both healthy and everything's fine, they have that in mind, and they a friend of mine just recently did the same, built a home, and she made sure that all the doorways, like from the garage into the house and the sidewalk into the door, were level, in case there was ever a wheelchair issue. Made sure they went ahead and put bars up in the shower. Didn't have the tub.
Didn't have to walk over that.
Exactly.
Well, in the U.S., 10,000 people a day turn age 65 and older.
Oh, that's an amazing statistic.
Huge,
10,000 a day.
Yeah, it's the fastest growing population in the U.S. And I encourage people, if you want to age in place, you're going to want to do those things that you were talking about with your friend that I was mentioning earlier. Get those things in place now. If you're waiting until the point that you need it, you're not going to have the energy, you're not going to be there and available to make those decisions that you might be able to make a little bit earlier. So I would encourage folks to make those decisions a little bit earlier as opposed to a little bit later. Clean out your closets and downsize if you can. Single-story home, fantastic. That home that you raised your kids in may not be the best home to retire in.
That has the bedrooms upstairs.
Exactly right. You got it.
Whatever. So I get that. Well, we've had a phone call, this one coming in from Dottie, and she said, how can a family member protect their parents' real estate assets. And that goes into what you mentioned earlier in terms of asset protection as we age.
Right. So great question, Dottie. I really appreciate your calling in. So oftentimes, if we can plan in advance for when you may need more care as you're aging and your medical expenses may increase, your care expenses may increase, oftentimes we create trusts, asset protection trusts. Those trusts can hold real estate, can hold other investments, brokerage accounts, some liquid cash, CDs, life insurance policies. You can put anything into those types of trusts, those asset protection trusts. If the assets are there for a period of 5 years or more and you need to provide or receive care in your home and you want to provide payment for that care and not using those resources that you put into that trust, you could look to other benefit programs like Medicaid or the Veterans Administration to be able to assist you in getting that care in your home that you need while protecting your real estate, Dottie, and any other assets that you may put in. So that's a great question. I appreciate that.
Yeah, and I think that's probably a question a lot of people are thinking about and wondering about.
Real estate's oftentimes, folks, their largest investment, right? They bought it. We were just talking before we went on the air, buying real estate years ago and how it's ballooned in value over time. And so that home that you bought back in the 50s, 60s, and gosh, you paid pennies for it in comparison to today's market, and you're looking at it now and it's several $100,000. You never anticipated getting that, growing that much, but it has. So how do we protect that? Oftentimes we use those trusts, those asset protection trusts. It's a great tool.
And I think a lot of people, not everybody, but a lot of people have maybe a second home, a vacation home, or a place at the lake, or a cabin in the woods, or
farm.
something.
Right, we have a farm, Grandma's farm, Mom and Dad's farm, and it's been there for a generation, 2 generations. It always breaks my heart when I hear that, gosh, we sold Mom's farm, we sold the lake house, we sold this house because they went into a nursing home or they needed that care. So we thought we had to sell that in order to provide payment for it. There are very many techniques to use in order to protect the lake house, in order to protect the farm, to protect your home in town. So please reach out to an elder law attorney and ask about how is it that you do that. It most definitely can be accomplished. You do not have to sell the property. It can be protected. But the earlier the better. It's never too late. Frankly, it's never too late to protect assets. There's always an option. However, if we can get you in earlier and we can get those things put in place, it's going to benefit you and preserve those assets for your future generations.
Well, we have another phone call, Bryan, and we always have a lot when Bryan's on, so make sure you get your phone number dialed right now. It's at the bottom of the screen, and we'll be here, obviously, until the end of the half hour. Niles phoned in, and he said, if 2 people have power of attorney, does it take both parties to probate the will? I don't know the answer. Do you? I hope you do.
I do. So thank you again, Niles, for calling in. I appreciate that. So you're talking about 2 different things, actually. You're talking about powers of attorney and you're talking about wills. So a power of attorney would be used during your lifetime. So during your lifetime, you're appointing someone that can do whatever you can do in writing. So signing your name, signing checks, buying and selling real estate, negotiating contracts on your behalf. Now, that power of attorney could be limited, saying you can only do this activity. You can only work with my checking account, or you can only work with my real estate. Or you could only work with this brokerage account. But typically, we're seeing powers of attorney that are very broad in nature. So the power of attorney actually doesn't relate to the will. So the power of attorney would be during your lifetime. The will would be after you pass away. So within the will, what you may be referring to is who's appointed as the executor, who's appointed as the personal representative in that instrument. So they're the person, if you've appointed them in your will, they're the persons that would take that will, file it with the court, open up an estate, and go through the probate process. So then, so spreading the will of record is the probate process, opening an estate, advertising in the newspaper. So your executors, your personal representatives that were appointed in that will, they're responsible for that. Oftentimes, clients are using the same person in the will to be the executor, the personal representative, as they would be in the power of attorney as their attorney in fact, but it doesn't have to be the same person. So, Niles, to your question, if 2 people have power of attorney, does it take both parties to probate the will? No, unrelated. I will take that a step further. In the power of attorney, It could be that you set it up so that you've got two agents, two attorneys in fact. You can set it up so that
You
both
mean
of
one person will have two power of attorneys? Is that what you're saying?
No, one person could write a power of attorney, and they're appointing two individuals to represent them as
Got
agents.
it. Okay, got
so
it.
we can write those so that both of them have to sign everything and act in tandem, or either one could do it. And in the will, we can do the same in the will. We can indicate that both people have to do everything together, or if we don't indicate that, either one can act independent of the other.
Okay, all right. Is this anything that a judge would order, or you make that decision yourself as you're doing your documents?
So the judge, so you would do that when you're preparing the documents. An instance, though, in which the judge may become involved and say, two people have to do this, or only one person is serving, is if there's a division between those representatives in the estate and they're not getting along, or the estate isn't moving forward, they're at loggerheads. In that instance, it could be that we would file a petition with the court and say, Judge, I've got two personal representatives. They cannot agree to get things accomplished, and they're really duking it out. Would you please make a decision for us either on this issue or who it is that should or shouldn't be serving as personal representative in that instance?
Got it. Okay. Thank you so much for calling in now. And James just called in as well. Another legal question coming up here. James wants to know, what happens to the assets of a single person?
Well, if you're a single person and you have a will or you've established a trust, we would look to that instrument. We would look to the will. We would look to the trust to determine what is it that you've said in that writing, in that written instrument, where your money goes, where your assets are to be conveyed. If you are a single person and you didn't prepare a will, you didn't prepare a trust, then we look to something called intestate succession. And intestate succession is a series of codes in the Indiana Code, in Indiana, Ohio Revised Code, wherever you may be, in what state you're in, and there will be a delineation of where the funds are to be distributed. So if you have children, for example, and you don't have a will, and you're single, we would look to that intestate succession code. And if your parents this is Indiana's intestate succession code. If you have parents, your parents are actually entitled to some of your estate, as are your children. If you don't have parents, then your children would receive all of that. So
even if you're single, and this is to clarify part of James' question, he's curious, what happens to the assets of a single person if they have kids, but they don't have a will. And you've addressed part of that.
Yeah, so if they have children and no will, we look to the intestate succession statutes.
Okay.
And it very clearly delineates who gets what percentage, but it doesn't always work as people would think. Right? We assume that if I'm married, everything goes to my spouse, or if I have children, everything goes to my kids. It really depends who in your blood family is living. Are your parents living? Are they not living? So it's not as crystal clear as you might think it would be. I'm certain that folks have the notion that, gosh, if I'm married, I know my spouse can make healthcare decisions for me during my lifetime, can make financial decisions for me during my lifetime, and when I pass, my spouse gets everything. That's not necessarily the case. So you would be encouraged to seek out the advice of an elder law attorney and make sure that your wishes are well documented, written down, witnessed, etc., and that you can put all of that into place.
Okay, all right, that clarifies a lot of that, and thank you for addressing that. Sure. Lucy has called in as well, busy on the phone tonight. Here's Lucy's question. She said, what is the difference between a trust and an LLC? Which is better to use?
So those are radically different instruments. We have trusts, we have LLCs. LLC stands for Limited Liability Company. So LLC is a type of company, limited liability company. We have members in that LLC, people that own, people that own an interest in that entity. It could be one member of an LLC, two members, right? Multiple members of the LLC.
Do you have to have a company or a business to have an LLC?
The C stands for company, limited liability company.
Okay.
So it is a company. You're forming it, and so you've created that company. Sometimes we would use LLCs as part of estate planning. So I'll get back to that in a moment. So the trust, though, a trust is I like to think of a trust as it's just a contract in essence. I've written this instrument. I'm indicating who it is that during my lifetime is managing it, the trustee, typically yourself, so you're the trust maker, you made it. Normally, assuming we're doing a revocable trust, you're your own trustee, and who's going to benefit from the money inside that trust. And typically, again, if you're writing it for yourself, you would be the lifetime beneficiary. And then when you pass, you would be indicating who is it that's the trustee at that time? Who is it that is the beneficiary, or who are the beneficiaries at that time? Children, charities, religious entities, whatever it may be. So we're normally, for estate planning purposes, transferring assets at the time of our passing, looking at using trusts. Limited liability companies aren't necessarily part of estate planning in and of themselves. I have used them to put real estate into, for example, if I wanted to transfer a farm or the lake house that Sandy was referencing earlier to loved ones. And how do we have something in place that allows the kids to know how that lake house is going to be managed? It's funny, just today I had lunch with another elder law attorney, and we were talking about establishing within that limited liability company who got to use the lake house on what weekends, what holidays, what everybody was responsible for. So we can do all of those things within an LLC or within a trust. But to answer your question, one isn't better than the other, but if we're looking at estate planning, we're typically looking at using trusts, not LLCs. And then during your lifetime, you could form an entity called a limited liability company, put assets into that. But that ownership interest of that LLC would normally be transferred into the trust. So they're not exclusive. They could work together, but we don't normally use an LLC for estate planning purposes.
Okay, that's good clarification.
Thank you.
And thank you, Lucy, for giving us the call here tonight. I'm curious if you want to leave certain things that you or your family considers very valuable to somebody in your family or a friend or whatever. How do you go about that to make sure that they get it upon your demise?
So if you're looking at an item of personal property, so let's say, gosh, this bowl is a family heirloom and I want to make sure it goes to a particular person. I'd like to see clients using something called a personal property memorandum. So you reference it within the trust, you reference it within the will, and you'll say, I have the ability to create this memorandum during my lifetime. And so I'm going to sign it and date it. And that memorandum then would be used to determine who gets that vase, who receives this table, who gets this pillow. So we want that to be in writing. The nice thing about that, using that memorandum, is if you change your opinion about who's going to get that pillow or that table, I can, instead of rewriting the entire will, rewriting the entire trust, I can just change the memorandum and I can amend that. That's an easy amendment, doesn't require those instruments to be rewritten.
Does it have to be notarized or legally done?
So wills are not notarized, trusts are notarized.
Okay.
So, and that memorandum can just be signed and dated. It doesn't need to be notarized, doesn't even need to be witnessed.
So you could attach that to your will or have that with your will and change it or add to it?
At any time.
If you needed to.
Now, if you're looking at a larger asset, we're looking at something more significant, real estate. I think we've got a couple questions about real estate. We've had that tonight. Or you're looking at a brokerage account or a checking account, savings account. I would want you to reference within your estate planning document, the will, the trust, who's receiving that. You could do a specific dollar amount, although I like to see percentages. I think percentages are cleaner than using dollar amounts because today I have $100,000. And so I'm going to say, well, person A gets $75,000 and person B gets $25,000.
Yeah.
But if I pass away and my estate is at $75,000, it's not as clean for me to be able to say this person gets $75,000, this person gets $25,000. But had I said 75% to this person and 25% to that person, and if my estate had shrunk, or had grown,
it'd be a different amount.
Your percentage would flow with it as opposed to a set dollar amount. So I like to use percentages, unless we're talking small dollar amounts, several $100s, a few $1,000s, something like that. Then I'm not as keen on having to have it as a percentage. But yes, I like to see the percentage
point.
as opposed to a set dollar amount.
We have another phone call, and unfortunately, we're very close on time for the end of the show, so we'll have to keep this brief, Bryan. But Mike called in, and he said, for an estate with no will, does a third cousin have any right to part of the estate?
All right, Mike, so you're going to really press me on my knowledge of that intestate succession statute. So what I would say generally is that if you are not married, your parents aren't living, your children are not living, your siblings are not living, there is literally a chart that goes out determining who it is that receives those funds. So is it possible a third cousin, without having that statute in front of me, it is possible that a third cousin may be in that intestate statute, that they would be able to receive some money. I remember in law school, my professor called that a laughing heir, meaning that we didn't anticipate getting any money, and what do you know, I'm a third cousin and I got some cash.
That's why people always look it up when we get the the big newspaper brochure.
The obituaries?
Unclaimed.
Oh yes, unclaimed property.
Yeah. You think, oh dear, somebody left me something and I don't know it. Okay, interesting. Now I'm going to have to go home and see if I have any third cousins. Thank you all for watching. Bryan, thank you for sharing your information tonight with our guests. And thanks so many of you for calling in. We'll be back next Wednesday night at 7:30, and we will see you then. Good night. Stay safe. Stay healthy.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, specializing in estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.